Over the past several years, the Supreme Court has decided several cases in favor of gay, lesbian, and transgender rights. It has legalized gay marriage, and it has ruled that the Civil Rights Act applies to gay and transgender employees. But conservatives are beginning to rely on other legal arguments to preserve the right to discriminate on the basis of sexual orientation or gender identity. Because much of the hostility toward LGTBQ rights arises due to people's religious beliefs, many of those arguments revolve around the First Amendment's guarantee of the free exercise of religion. Conservatives argue that prohibiting people from discriminating against gays violates their right to freely exercise their religion, and that it, in fact, constitutes discrimination against religious people. Supreme Court Justice Samuel Alito articulated this argument in his dissent from the decision to legalize gay marriage. He wrote, "Today's decision will be used to vilify Americans who are unwilling to assent to the new orthodoxy." In the same case, Clarence Thomas wrote, "The majority's decision threatens the religious liberty our nation has long sought to protect." As the court has gotten more conservative, it has more consistently taken the side of religious business owners. The most famous example involved Masterpiece Cakeshop in Lakewood, Colorado. Masterpiece Cakeshop is owned by Jack Phillips, an evangelical Christian. As its name implies, the shop makes gourmet cakes and other baked goods. In 2012, a gay couple asked Phillips to make a cake for their wedding. Phillips refused, saying that he was opposed to the concept of same-sex weddings because of his religion. The state of Colorado filed a lawsuit against him for violating the Colorado Anti-Discrimination Act. Phillips argued that the law was unconstitutional because it violated his right to the free exercise of his religion. The Supreme Court decided the case in 2018. In a 5-4 decision, the court ruled that Phillips did indeed have the right to refuse to make the cake. And this case was just the tip of the iceberg. In the court's 2022 term, it will consider an appeal from Yeshiva University in New York City. Yeshiva University is an Orthodox Jewish university, and while most of its students are Jewish, it is open to all students. In April 2021, the university denied a petition by a group of students who wanted to establish a Pride Alliance club of gay, lesbian and transgender members. The City of New York's Human Rights Commission ruled that the university's refusal violated the city's civil rights ordinance. Rather than permit the club to exist, the university disbanded all clubs on campus. It also filed an appeal to the Supreme Court. With the court's current conservative majority, it is almost certain that the university will win. And conservatives are using the free exercise clause to challenge other laws they don't like. In a 5-4 decision in 2014, the Supreme Court decided in Burwell v. Hobby Lobby that certain companies can refuse to provide birth control as part of their employees' insurance on religious grounds. In April 2022, a federal judge in Texas struck down a federal law requiring that insurance policies cover a drug that prevents transmission of the HIV virus, arguing that it violates the religious freedom of those who believe that homosexuality is a sinful lifestyle. As another example, also in April 2022, a nurse working at a pharmacy was fired from her job for refusing to provide contraceptives to customers due to her religious objections. She is now suing the pharmacy for violating her religious beliefs. Conservatives are also using the First Amendment's guarantee of freedom of speech to legalize discrimination. For example, in the Supreme Court's 2022 term, it will hear a case from a woman who designs websites. She was sued by the state of Colorado after she refused to design websites for LGTBQ weddings. While this is very similar to the Masterpiece Cakeshop decision, this case is about free speech rather than freedom of religion. She argues that designing a website is a form of creative expression, and that under the First Amendment, she cannot be forced to express a belief she does not agree with. Once again, the court's conservative majority will almost certainly decide in her favor. One logical question that flows from all of this is whether the same logic would apply to racial discrimination. In other words, if a cake shop owner or website designer believed that interracial marriages were immoral, would they be permitted to discriminate against interracial couples? The court has yet to provide a clear answer to that question.